We didn't have a chance to cover ABA model rules under part 6 of the model rules in the class, but I think it's important to at least provide this short video, talking about the various sections of that model rule and why they're important. If not for this class, because I'm not going to test you on them, but for your future as a professional. And part of that is that we have a duty to give back. And if you look at the aspirational model rule under 6.1, it is not mandatory, but it does say that every lawyer has a professional responsibility to provide legal services to those unable to pay. So even if there's not an hour requirement, it's something that we ought to consider part of being a member of the profession. And many of you already have a good start on that. You've been involved in the ProBono initiative. You've also served in one of the clinics and done good work there. And you know how meaningful that is and how good it feels to help someone who can't otherwise afford to hire a lawyer. A lot of law firms encourage pro bono service in their associates, and in fact, some of the bigger firms, the national firms, will even allow an associate to spend 3 or 4 months working for a legal services organization as part of their duty to the firm. So I've talked to some lawyers who have done that, and they said that was really one of the best experiences they've had professionally. Now, states do different things, so you need to check and see whether you have mandatory pro bono in your state, mandatory pro bono reporting. I have that in Florida. I don't have to do any amount of hours particularly, but I do have to report what I've done in terms of pro bono to the Florida bar. So you just need to make sure you're up to date with your bar once you're out in practice. Mississippi has considered mandatory pro bono and not elected to make pro bono mandatory. New York, it's mandatory. It's even mandatory before you become a member of the bar. So check this out. I mean, make sure you look at it for your particular jurisdiction. But you notice that the ABA model rule, it makes it aspirational. So it says a lawyer shall aspire to render at least 50 hours of pro bono legal services per year. And, those 50 legal hours should be without expectation of fee to persons of limited means, or this is where I think, the broader definition really helps if you are involved in providing help to your church or your religious organization, your charitable organization. So, for example, if you serve on the board of Boys and Girls Clubs or United Way in your community, those are all ways to help, because those are organizations that are designed to address the needs of persons of limited means. So they're ways to serve without having to deal with direct client if that's better for you. And notice that provide additional services through a delivery of services at no fee or substantially reduced fee to individual. A lot of lawyers will tell you they do low bono because they have a hard time collecting. But, it's something that is, we are members of a profession, and we serve the greater society as members of the profession. Yes, we need to make a living as well. So, these are aspirational. It's always a balance for states to decide whether they should make pro bono mandatory. I've had people say to me, if it's mandatory, it's not voluntary, so how can it be pro bono? And I do somewhat understand that argument, but this is an important aspiration anyway, that we do as much as we can. And except if you're in a state where it's required or you have to report it, then you need to think about what counts as pro bono. And notice it really is a pretty broad definition, not just direct client service, but also service to organizations. So, for example, you could do intake interviews for legal services, and that would count as well. In addition, a lawyer should voluntarily contribute financial support to organizations that provide legal services to persons of limited means. I can assure you that when you get your bar statement, one of the things that they will ask is if you want to make a contribution to legal services, contribution to organizations that protect children's rights. And so, they're usually check the box and you can add $50 or whatever you think you want to add. as well. And so that's another aspirational goal. And you look at the comment, it says every lawyer, regardless of professional prominence or professional workload, has a responsibility to provide legal services to those unable to pay. And sometimes firms will actually pay other lawyers to do their pro bono, interestingly enough. Right? And you could look at the comment. I mean, basically, pretty straightforward. What's the expectation? And just wanted to make sure you knew that there was some requirement to provide legal services and some professionally. And again, whether that is going to be something that you have to do or not is really up to your state bar. So now let's go to Model Rule 6.2. You're going to have to watch my screen. This is fun, isn't it? It's just like in class. All right. So the other thing that I wanted to point out is if you are appointed, and some of you will be appointed as relatively new lawyers, the first step is we should accept those appointments. A lawyer, you can see the rules, shall not seek to avoid appointment by a tribunal to represent a person except for good cause. So when could you beg out of an appointment? A, B, and C, there are going to be times when you may not be able to. And one time was, if you've got a conflict of interest, you can't represent that client. You're supposed to, the court appoints you to represent someone in a criminal proceeding, and somebody in your family was the victim of that crime. Obviously, you can't represent that person. Or, maybe, you've got, you represent a landlord and you're appointed by an organization to represent someone who's being evicted. You can't do that if the landlord is the one evicting them. So, that would be a violation of the rules of conduct, professional conduct. Or representing the client is likely to result in an unreasonable financial burden on the lawyer. It will result in a financial burden. If you take on a client by appointment, the state or county may pay you something, likely not the fee that you would charge your clients, especially if you're doing, say, a lot of business clients and things like that. But it's an unreasonable financial burden that they're looking for. So, for example, they assign you to a case, they appoint you to a case that's going to take all your time and all your effort for 3 years. You could say that under Rule 6.2b that's going to be an unreasonable financial burden. We're not asking you to give up your practice to take care of a particular client. C is a harder one. The client or the cause is so repugnant to the lawyer as to be likely to impair the client-lawyer relationship or the client's or the lawyer's ability to represent the client. So, again, I mean, even if you're appointed to represent someone who is a member of the KKK, you could make the argument that they are so repugnant to the lawyer. But again, that person is entitled to legal representation. So someone is going to have to do it. You have to make that argument to the court that representation is so repugnant. Let's look at a comment on that. Right. Again, you got, for good cause, a lawyer may seek to decline an appointment to represent a person who cannot afford to retain counsel or whose cause is unpopular. Good cause exists if the lawyer could not handle the matter competently, if undertaking the representation would result in a proper conflict of interest. We talked about that. A lawyer may also seek to decline an appointment if acceptance would be an unreasonably burdensome or would impose a financial sacrifice. Right? So, they really don't talk much about the idea of they really don't talk too much about the concept of repugnancy. So that's going to be subjective and something that you would have to consider yourself and argue with the court. They're not typically, just because you don't like the clients, not enough to avoid that appointment. So it's going to depend on your jurisdiction as well. Again, this is something that the model rules are the starting point. But when you get to the rules under 6, you really need to look specifically at the place you're going to practice and see what that rule is in your jurisdiction. All right. Now, the other thing is, can we serve as directors, officers, members of legal services organizations? Well, I am a member. I'm on the board of North Mississippi Rural Legal Services. Yes, we can, but we cannot participate in a decision or action that would be a violation of Rule 1.7, conflict of interest, right? So again, if I'm working in an organization, they do a lot of good work for people who can't afford legal services. It's possible that organization is in conflict with one of my current clients. So I cannot be part of a decision that affects my current client. I don't have to get off the board because the board might be doing a lot of different things, but I can't be involved in that decision. Or where the decision or action could have a material adverse effect on the representation of a client of the organization whose interests are adverse to the effect of the client of the lawyer. So I can't do anything to harm the organization's client either. It makes sense. And really, again, what we're really concerned about there are conflicts of interest. All right, we can, law reform activities, right? Okay, so we can work at organizations involved in law reform, even though that may affect the interest of a client. So, for example, if I am in an organization that is advocating for changes to food policy, even though my client might be an organization that is affected either positively or negatively by that food policy, I can disclose that fact, and especially if it's favorable to my client. If I am working for Coca-Cola and I am advocating that sugar really is not bad for you, it's really one of the best things you can have, and it has great benefits, and we want to stop regulating sugar, just as an example. I can be involved in that law reform activity, but I got to disclose that I'm representing a client who will benefit from that activity. So, yeah, we can do public service in activities that advocate for changes to the law as well. And nonprofit organizations, what this really is, I'm going to quickly talk about this rule as unbundling. Notice it says a lawyer who, under the auspices of a program sponsored by a nonprofit organization, provides short-term legal services to a client without expectation of continuing representation is subject to the rules of 1.7 and 1.9 only if the lawyer knows the representation of the client involves conflict of interest. So again, this allows us to do short-term limited services. That is a concept that is very fortunate for legal services programs, because prior to that, if a lawyer interacted with someone on behalf of a legal services organization, the assumption was that lawyer was the lawyer for the whole process, start to finish, intake, interview, all the way through trial, if that was the case. What unbundling did, 6.5 did, is it says you can represent somebody in a short term. So I can do intake interviews for legal services organizations. And even though that may create a lawyer-client relationship, an attorney-client relationship for that short relationship, it's limited. So, for example, I'm doing an intake interview, and a client calls up and has a complaint about their landlord in that intake interview, and they're the type of client that maybe the legal services organization would represent. I find out that the landlord they're complaining against is my client. Then I have to withdraw from that representation. But that doesn't disqualify the entire organization from taking that on. Right? So it's subject to Rule 1.10 only if the lawyer knows that the other lawyer associated with the lawyer in the law firm is disqualified with 1.7 or 1.9. So it allows us to take on a short-term limited representation, and while the rules apply, the whole organization will not be disqualified. So let's go to the next rule. All right, and there we go. So we're done with rules under 6, and that is what I wanted you to know, not for this class, but for life. So you do need to know Rule 7.1, and could be tested on that.